Hey everyone, welcome back to today's video. We've got a lineup of wild hearings to cover. 2 fools pushing their luck with the wrong judge, 2 judges stepping down for all the right reasons, and an update on everyone's favorite sharp-tongued Eric Martin. First up, we're heading to Connaught Municipal Court, where one genius, already out on bond for driving without a license, decides it's a good idea to keep hitting the road.
Constantly being in this courtroom, driving against court orders, while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr.
Absolute powerhouse. He's fair, he's strict, and he runs his courtroom like it's his kingdom. And guess what? We're sticking around for the next case because it's happening right in front of a group of young kids on a courthouse field trip. These kids are about to get a first-hand lesson in the classic principle of mess around and find out. All right, miss, let's see how this one unfolds.
Did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever?
What did you mean by non-political whatever, Nadi? Excuse me, did you just say that? What did you mean by non-political? You know what? Take her into custody. Did you just use that language in front of these kids and in front of me? Really? Take her into custody, send her down to jail, and think long and hard about what you just said in my courtroom in front of these kids. Maybe, just maybe, I'll consider bringing your case back up later today. But for now, get out of here. Spoiler alert. He didn't bring her case back up that day. Not that it really mattered in the grand scheme of...
Take her into custody. Did you just use the F word in front of these kids and in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir,
Get out of here.
An attorney steps away from a case, it's usually at the request of the defendant. We see this a lot with sovereign citizen trials. The defendant fires their lawyer after realizing the attorney won't indulge their fantasies of make-believe legal theories. They hope the next lawyer will join them in their crayon-flavored delusions, but in this situation, things are flipped. Here, the defendant and his attorney can't agree on legal strategy. Now it's the lawyer requesting to be recused, likely because he's not comfortable staking his legal license on the defendant's frivolous motions. Plus, I imagine he feels pretty hamstrung trying to work alongside the defendant's second legal team from the prestigious firm of Pro Se, Dick Flutt, and Dumbass. All right, so counsel...
388, the state of Michigan versus Bradley Peterson. Okay, counsel, you're, Mr. Perpenwalk, Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Bradley Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this.
I think it's in your best interest to represent yourself, especially when you don't even know the basic procedures. For things like requesting court transcripts. Clips that, my friends, is a bold-faced lie. See, I'm one of those odd content creators who actually takes the time to research the case history of the people I cover. And I especially enjoy it when they make factually incorrect statements, only to hand me the exact breadcrumbs I need to prove they're lying. In this case, he cited Judge Grant in his lawsuit against the city of Woodhaven, which led me to a federal case in the Eastern District of Michigan, Brad Peterson versus a lot of defendants. And when I say a lot, I mean he literally sued the state of Michigan, the city of Woodhaven, the mayor, the presiding judge, and the prosecutor for civil rights violations. Now, he claims that the city put out a protection order, PO, on him. There is indeed language in the opinion that hints at this being true. However, when he appealed after losing, the following paragraph surfaced. Peterson's failure to object to the report recommending denial of his motion for an injunction permits the court to adopt it without further comment. However, the court agrees with the findings and conclusions in that report. That single statement says so much while saying so little. It confirms that Peterson filed a counter-request for an injunction against an injunction that was placed on him, preventing him from violating a sign ordinance in the city of Woodhaven. It also confirms that even if he had appealed that injunction, the court would have ruled against him anyway. Now, Magistrate Grant did dismiss several parts of Peterson's lawsuit, but here's the catch. Those were pretty much all the frivolous claims that Peterson himself filed. What didn't get dismissed, contrary to his claim, was the city's injunction against him. To put a final stamp on this side story, in December 2024, the appellate judge ruled to dismiss all charges against the state and its co-defendants. With prejudice. So let's be clear. Stop lying. You're way too old to still be pulling this nonsense.
To be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case, is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today, asking for this court.
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. Yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just on transcript.
recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts.
Okay.
You can just request the transcripts.
Okay, yeah.
There's a fee that you have to pay, but it's
On the Michigan Court Rule 2.003, I believe it's filed that on the 17th on Friday or something like that. So
okay, hold on, just one moment. Okay, well, counsel, I will allow you to, I will grant your motion to, terminate representation specifically, as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course, I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one. You filed something on January 17th, and you're requesting our 2.003 to dismiss, disqualify the judge as follows. File the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at city and Wyndham public schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not
reading,
at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he.
Please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir?
I'm with you on.
the allegation is that you assaulted, resisted, obstructed a police officer causing injury and trespassed.
That's
Now,
just an allegation.
you're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
Yeah, you need to read the whole thing of it, just one. I got like 15 issues in there.
15 issues.
Yeah, you
Okay,
need to
so,
read the whole thing. Also, Your Honor, I publicly protested today in front of your court,
okay.
but none of your police came out to arrest me because that's my constitutional right to do.
You're
I'm
correct.
not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again. Actually, I wrote one of your white laws. I follow them, and then you stomp on me when I follow your laws. You've been doing this for hundreds of years. You know,
Pause.
Martin Luther King
Pause,
marched,
sir. Pause.
and you
Pause.
guys
Stop
kicked
right
dogs
now.
out.
Stop right now.
You
I'm
brought it
not
up,
100
right?
years old, so do not accuse me of stomping on anything.
Well,
Let's be very clear on that.
yeah, well, okay. Yeah, it don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven though, and now you condemning me for it
No,
because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also
No.
took an oath to uphold every citizen's constitutional right to public protest, but
Okay.
you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right? So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere, you can't go on any public property. I have not done that, sir.
You did.
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the US Constitution as well. That's
I don't
statutory authority. Whether you agree with that or
I
not,
don't
sir.
agree.
I understand, you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim. I'm
Which
the
this
victim.
court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse and it was okay. You should have arrested me then. When I go to your
So
schools
I don't
and you're
have
wind
arrest
out,
powers.
when I go to schools and you're wind out, you should have